850-8585.
Morning.
That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody, and as I said on the Facebook feed here, I hope we don't get seasick today watching this episode. I hope I don't get seasick sitting out here. I am on the ocean at Jupiter Beach. I thought I'd try things a little different today. I'm here to bring you a show live from the boat. This is 30 minutes of free legal advice, and I'm here every Saturday morning, typically at home. But as I mentioned today, I'm on the ocean. But still, you can call into the program anytime that you want. You heard the telephone number there at the outset, but just in case you didn't get it, the telephone number is toll-free, 877-850-8585. Call into the program and ask me anything that you want. I have a topic on tap for today. My topic comes from a conversation that I had with somebody earlier in the week on what we call the statute of limitations, what we officially call the period of limitations in what we do, and most of them are contained in Florida Statute 95.11, so I'll be going through that statute in some detail. But of course, I always give priority to those people that call into the show and whatever your issues may be. I did get another condo HOA question during the week, and the questions, although the facts are not always the same, the issues always tend to be the same, and that is that somebody's having an issue with the board, or one of the rules and how the board is enforcing the rules, or perhaps selectively enforcing the rules against some people and not others, and what can they do about it. And unfortunately, condo law is not what I do day in and day out, so I often have to punt. I make that recommendation, call a condo attorney, get some really good advice. But for this particular question, the issue was, the majority of us in the neighborhood want to see a change to a given rule. What do we do about it? Well, in that instance, and if you're in that boat, pun intended, then duly notice the issue at a meeting. And when I say duly notice, make sure you follow the rules. The condo docs, the HOA docs will oftentimes tell you exactly what you have to do to put something on the agenda so that it can come up for a vote. If it's duly noticed, and if in fact the majority wants this change, then put it to a vote. And hopefully the majority shows up, and hopefully you get your change to your condo docs for whatever it is that you're trying to get. I know that my neighborhood just recently passed a new rule. The old rule used to be can't have pickup trucks, like probably 99% of the associations in the state of Florida. Well, nowadays, as we all know, pickup trucks are becoming a very nice vehicle, very expensive vehicle, not an embarrassment to have in the driveway. And so our association just recently passed a new rule saying, okay, you can have pickup trucks. I do believe there are some parameters as far as how old the truck can be, whether there can be any writing on the truck, which the answer is no, that kind of thing, so that you're not having an old jalopy or a work truck sitting in your driveway. That's still not a. But for the person that contacted me about the condo HOA question, there's your answer in a nutshell. If you really want to do something about it, if you really want to make sure that you're dotting I's and crossing T's, then contact a condo attorney or an HOA lawyer. And if you need referral for one, give me a call. I'll be happy to throw a couple names out there. I actually did that twice this week because I actually have a client of mine who I spoke with about his case, and then when we were done talking about the case I have with him, he mentioned a condo issue, and so we got into that same conversation. But earlier in the week, let me do a little self-promotion real quick just to get it out of the way. And I see that my mom is watching this morning from North Palm Beach. Mom is in from Tennessee. Good morning, Mom. Nice to see you. Self-promotion, this program is brought to you every week by my law firm, which is Vastola Legal. And so if you'd like to contact me directly, don't even worry about calling the office. If you have an issue and you want to talk to a lawyer, call me directly. The number to call me directly is 833-VASTOLA. That's 833-827-8652. That number is forwarded to my cell phone 24/7. I never turn off the forward, so you always get my cell phone. Now, you may not get me. You might get my voicemail. But if you do, leave me a message and I will call you back. Sometimes the call back is a message to you suggesting that maybe you should call me on the radio show. I do get a lot of phone calls that that come into my cell phone because I'm encouraging people to call me on my cell phone, but what they're calling to talk to me about are things that they should be calling the radio show so that everybody can hear it, because your issue may not be your issue alone. You might share that issue with a lot of people, and so I get to decide, is that a radio topic, or is it something that we need to talk about in private? If it's something we need to talk about in private, then of course I'll have that conversation with you. But feel free to call me, 833-VASTOLA. You can use that number anytime. And as far as locations go, we have an office up in Stewart. I say up because I'm pointing north. We have an office in Palm Beach Gardens down south, and then we have an office down in the Florida Keys. So if you know of anybody that's down there, has any kind of an issue, have them call me. We actually have an office down there where we can meet, and I'm happy to talk to anybody about it. If you want to find out more about me, just because you're curious or because you're vetting lawyers, go to vastolalegal.com. That's my website. You can find out all about us, our location addresses, phone numbers, all that kind of stuff. So anyway, thank you for watching this morning. Again, 30 minutes of free legal advice, and I felt compelled to talk about the statute of limitations in Florida because of a conversation I had earlier this week. And unfortunately, I was talking with what we call a potential new client who had a malpractice issue, medical malpractice issue. And at first blush, the facts of the case sounded as though it was meritorious, as though she would have had a good case. But then as I started talking about the chronology and when did things happen and who did what, I realized that she was complaining about an event that took place 4 years ago. And so I immediately interjected and said, no, wait a minute, are you talking about an incident that happened 4 years ago, or is that just when everything started and then the malpractice happened sometime later on? And so she did confirm, no, I'm alleging that the mistake, the malpractice, was 4 years ago, and I had to immediately tell her, based on the facts of the case that we had already talked about, I'm sorry, there's really nothing that I think I can do for you because you waited too long. And the reason why I feel compelled to talk about this topic today is because of her response, and I don't blame her, but her response was, how can I be to blame when I didn't know that? And I hate to say it, and I didn't want to drag out this old ugly cliche, but there is a cliche that says ignorance of the law is no excuse, and that's precisely what happened here. If you don't know your rights, then you can lose them. And so not only is the medical malpractice a 2-year statute of limitations, which of course we call a period of limitations in what we do, it's a deadline. It's an absolute deadline. Now, I say absolute, every rule has its exceptions. And there are some exceptions specific with regard to medical malpractice and when the 2 years begins to run. Let me try to make it as simple as I can. If the malpractice is obvious, if you go in for an amputation of your left leg and you come out and they've amputated the right leg, they've made a mistake, you know when the mistake happened. Okay? If you know when the mistake happened, then your statute of limitations, your 2 years, your deadline, will begin to run from the day of the incident. Now, technically, case law says you don't count the day of the actual mistake, so you wouldn't count the day of surgery. But conservatively, in my office, we always start a period of limitations in a medical malpractice case, a 2-year deadline from the date of the surgery, the procedure, whatever it may have been. I like to use a very conservative date. And then, although it's a 2-year deadline, I give myself 1 year and 11 months for our calendar, just as a red light warning. Hey, be careful, statute of limitations is coming up. I mean, it's so important. We have so many reminders on our calendar about these things. But if you're not a lawyer, then you may not know about it. So different cases have different deadlines. As I was going to explain, the medical malpractice statute, if it's not obvious as to when the incident occurred, when was the negligence, then there is a standard that's written into the statute, and I'll read it for you in just a moment, but essentially is, when should you have known with reasonable due diligence, or something to that effect, when you should have known of the incident. So if you have a procedure and after the surgery you're going months and months and months and months and months and you just don't feel right, and now you've got all kinds of new symptoms, you know, you're bloating, you've got pain, and then, you know, 6 months later, you know, you go in for another procedure and you find out, well, you know, they nicked your bladder, you know, something like that during the procedure, which isn't necessarily malpractice. It depends on the facts and everything else, but just as an example. sometimes it's not entirely clear when you knew or should have known of the actual negligence, because you didn't know the day after surgery, because the day after surgery you've got pain. You just had surgery, so all that belly pain and things, you probably thought that was part of the procedure. But if you don't find out until 6 months later, then the question becomes, well, geez, when within those 6 months should you have known that something was wrong? And that's a difficult balance in what we do. In my office, we always take a very conservative approach, and we'll start counting from the date of the surgery, even though realistically you didn't know from the day of the surgery. But that's just so we're being overly cautious so that we don't, what we call, blow a statute, and you don't want to do that. And that's unfortunately what this young lady did, not intentionally, of course. She didn't know that she was going to hurt her chances to be able to bring a claim, but she was very persistent about, how can I be to blame when a typical layperson is not going to have this information? And I said, well, I applaud you for not, pulling out the phone book and your first phone call being to a lawyer, because, in our society, people kind of thumb their nose at that. But the reality is, if something's happened to you and you don't know what your rights are, and specifically, what is the deadline for me to do something about this, then your first phone call should be to a lawyer. Not necessarily to hire a lawyer, but to get your questions answered, and specifically to be told, this is how much time you have before your deadline is going to expire. And that, I encourage people to call me all the time with questions, and that's really the reason why. I always say, you're not obligated to hire me if you call me. I'm here as a resource to answer questions for you. I'm here every Saturday morning to answer questions for you. And by the way, I'm going to bring it up again because I haven't mentioned the phone number in a while. I do want you to call into the show. I've heard people tell me, and I appreciate this, we didn't want to interrupt you. Your topic was interesting, and I didn't feel my topic was more interesting than yours. But I promise you, the show is more interesting when we interact. So if you have a question, please interrupt me. The number is 877-850-8585. Boat just went by me, so I'm going to get rocked and rolled here in a minute. But that is the number to call into the show, 877-850-8585. Now, I've been talking with you guys about how I like to be a resource. I'm there for you to ask questions. If you would like to call me directly to talk about a case, and if it's not something you want to share the details with everybody in radio land or Facebook land, then dial 833-VASTOLA. That's another toll-free number that goes to my cell phone. We can have a quick private chat. The answer to the question of how can I be to blame when I didn't know is, unfortunately, the law is there for everybody to see it, for everybody to read it, for everybody to know it. So I encourage anybody that's been involved in something where they think they might have some kind of a claim, just know what your rights are. If you sleep on your rights, you can lose your rights. So anytime I decline a case, which is frequently, especially medical malpractice claims, they're very, very difficult claims to get up and running, and the percentage of decline is much higher than the percentage of cases that I actually take. And our decline letters are very specific to tell people, look, we're declining the case, but I strongly encourage you to reach out to somebody else, have another conversation, make absolutely certain that you don't have a case before you just walk away from this. And one of the things, the very last line is, remember, Florida maintains very strict deadlines, and you have to meet those deadlines or your rights will be forever lost. That's actually in my letter. So important. And that's why it's my topic today. So, if you're interested in finding out more about the periods of limitation for all different kinds of cases, I told you I was going to rock and roll. Boats on both sides. The wakes are meeting up right at I hope this isn't too awful as you're watching this. I'll watch later on and see if this is something I do again. I'm actually not feeling it that bad because I'm up in the front. But anyway, it's a beautiful day out here. It is going to be hot. If you were listening at the outset of my program, you heard on the radio that it's going to feel like it's in the triple digits today down here in Florida. So, within 5 years. Now, there's some interesting quirks with the periods of limitation that apply to different types of claims, and one of which I talk about all the time is a contract. Okay, sometimes you have a contract, and you have a contract more often than you think you do, by the way. Every time you go to a gas station to buy gas, that's a contract. Every time you buy a pack of gum, that's things like that. Every time you go to the grocery store to buy groceries, that's a contract. But, of course, those contracts are not frequently litigated. But contracts can be written, they can be verbal, and there can be different remedies that you seek depending on what the other person was supposed to do, or what they did and they were not supposed to do, whether you are alleging a breach or whether you're looking for what's called specific performance, where you're wanting somebody to actually do something according to the contract that they're supposed to do and they're refusing to do it. But depending on what you've got, you might have a shorter deadline. And specifically...
Hey, Jeff?
Yes?
We have Sean from Green Acres calling.
Oh, wonderful. All right. Sean from Green Acres, let's get him or her on the line. It's one of those androgynous names. Let's see who is Sean. Good morning.
Good morning. How you doing?
Good, Sean. How are you?
I'm hanging in there. I can barely hear you.
I'm sorry. I'll pull my computer right up to me. So, what can I do for you? I don't. This is an area that I don't practice, but as I promise everybody, Sean, when you ask me a question on the air and I don't know the answer, I'll do the research and I'll make it a topic for next week. So I'm happy to do that for you.
Okay. All right. I was just curious what you knew about that.
Yeah. Unfortunately, nothing, because it's not an area that I... Sorry to hear that. Right. Well, Sean, just tell me real quick, for how many years did you not pay the mortgage? Because that's information that I might need. Okay. All right, well, let me do some research. Tune into the show next week. I'm going to make it a topic for discussion. If you happen to miss the show, every show is uploaded onto my YouTube channel and onto my website. So you can go there if you need the information and you weren't able to listen. All right? All right. All right, sorry to put you off for a week, but I mean, if I had any insight at all, I would tell you. This is just an area I know nothing about. All right, Sean, thanks for calling in. I appreciate it. Dan, thanks for putting him through. I was going to see how much time I have left, because I feel like I've been talking for probably about 30 minutes. Oh, I've only been talking about 20 minutes. So let me talk about the different types of deadlines that are applicable. I think I was talking about a contract, right? Breach of contract. If you have a written contract, the statute says you have a 5-year deadline. If you have a verbal contract, your deadline's only 4 years. So keep that in mind. I mean, you might have the assumption because somebody told you sometime that, hey, breach of contract's 5 years. It's not if you don't have a written contract. And specifically, depending on the remedy that you're looking for, your deadline could be even less than that. I mentioned a moment ago that if you're seeking what's called specific performance, if you're going to ask the judge to enter a judgment forcing somebody to do something that the contract says they're supposed to do, but they're just not doing it, that's specific performance. You have 2 years to bring a lawsuit for specific performance from the date that they breached, from the date that they weren't doing it. So even though you've got a written contract, you may think, well, I've got 5 years, I've got a written contract. It depends on what you're looking for. And it's all in the statute, and it's all there for you to read. It's Florida Statute 95.11. So if you have any questions at all, oh, my computer, there we go, it just came back up again. Look at Florida Statute 95.11. Now, keep in mind, I'm only licensed in the state of Florida, and I can only give you advice that's good in the state of Florida. You might be listening to my show from, my mom often listens from Tennessee, or I've got cousins that are up in New York. please understand that every state's laws on these kinds of issues can be different and often are times different. I found out, I represent a client who was in an airport in another state and had a slip and fall incident. I'm not licensed in that other state, but I can certainly try to resolve a claim without filing a lawsuit. I represent her here down in Florida, and I can try to resolve the claim outside the state. But I found out by doing due diligence and contacting an attorney up in that other state, what is your deadline for an injury claim? In Florida, it's 4 years for this particular type of claim. In the other state where she was in the airport, it's 2 years. So, you know, even as a lawyer, if you're not on your game, you can really let something slip. And when you do, it's tragic, because as I was explaining to this person that called me earlier in the week with this medical malpractice case, and I unfortunately had to tell her that, you know, look, you slept on your rights, I can't help you. There are no exceptions. I mean, there are no get out of jail free, I know that's kind of a bad slang, but there's no free pass other than what the statute says about when you knew or should have known. But her incident that we were discussing was so clear as to when the date of the incident was. It wasn't an amputation of the wrong leg, but it was something pretty obvious. When you wait, there's no exception, and unfortunately, you know, I didn't want to have to give her that news, but it's unfortunate. But that's why I've made this my topic today. I'm seeing on Facebook, my mother's asking me, what was Sean's question? I guess you guys on Facebook weren't able to hear from my laptop. Sean called in with a question about his mortgage. He had not paid the mortgage in quite a long time. He has an attorney representing him to defend a foreclosure action that was brought, but he's learned through speaking with somebody that if you don't pay a mortgage for so many years, there is some law, I don't know it, I told him I'm going to research it, that says the bank has slept on its rights, has foregone the opportunity to foreclose. So I know nothing about that stuff. I'm going to educate myself, and I'm going to give Sean the answer to his question next week, and hopefully it's a decent answer. But we'll see how that goes. I mean, I'd be shocked if, I mean, there is a statute of limitations for foreclosure, and if the banks sleep on their right, the same way you can sleep on your rights for medical malpractice or breach of contract or negligence or whatever, then sure, they're not going to be allowed to bring that action. But if they bring the action timely, I'd be shocked if there's some rule that says because somebody didn't pay for so many years that they're not allowed to foreclose. But I don't know, maybe it's out there. I know there's a lot of favorable law for homeowners. What else is interesting in Florida Statute 9511? So basically 4 years is the most popular deadline. The period of limitations is that 4-year period has most of these things. A lot of times a statute will say you can be liable if you violate this statute. Okay, civil theft. That's a good example. Okay, there's a statute in Florida which regulates civil theft, but it doesn't say how many years you have to file the lawsuit. This Florida Statute 95.11 is kind of like the safety net that catches all of those deadlines that aren't specifically stated in other statutes, and it says if there's an action founded on statutory liability that is not expressly stated in the statute, it's 4 years. Okay. Now, that doesn't mean that all statutory liability is 4 years, because a perfect example is wrongful death. Wrongful death is a claim that's regulated by a Florida statute in the state of Florida, and that statute specifically does say that your deadline to file a wrongful death claim is only 2 years. So don't think that because Florida Statute 9511 sub F says an action founded on statutory liability that you're going to have 4 years to file a wrongful death claim. You have to go to the wrongful death statute, and if your statute gives you a lesser deadline, a lesser time, then that's what you have to work with. So, like I mentioned, there's a lot of pitfalls in what we do. A lot of this stuff is learned in law school. Not a lot of it, to be honest with you. Most of this is practical. A lot of law school is legal and logical thinking is what it is. But the Florida bar exam prepares you for stuff like this. And then, of course, as you get out there and start practicing day in and day out, you really kind of learn your trade. But if you're interested in finding out what is the deadline for a certain type of case, then go to Florida Statute 9511, because it's a pretty simple read. You don't need to have a law license to understand it. least most of it. And all right, I've got 2 minutes. Actions within 2 years are, oh, by the way, action for assault, battery, intentional conduct, those are 4 years. I just filed a lawsuit this week for another one of these. Just, there's really no proper adjective for it, but just a grossly intentional act, a murder-suicide that happened up in the northern part of Florida. And you know, when that came in, of course, we kind of looked at everything. I had to refresh my recollection. Okay, well, is it you know, a 4-year or a 2-year? Well, okay, you might be looking at the statute to say, well, this is an intentional tort, a murder, it's an assault, it's a battery, it's a murder. The statute says that's 4 years. Well, keep in mind, it's also a wrongful death claim. And because it's a wrongful death claim, the period of limitations is 2 years, not 4. So, all right, 1 minute left. I'm going to go ahead and wrap it up with this. Thank you for joining me today. Hopefully you didn't get seasick. And if you want to talk to me about anything personally, call my cell phone, 833-VASTOLA. That's 833-827-8652. And if I don't answer the phone, leave me a message. I'll get back to you. And I hope everyone has a great weekend. God bless. Thanks for watching.